Good evening, listeners. Thank you for tuning in to the third show of Legal Talk with Patricia Bryan. I'm so excited to be here again, providing you with more experts to discuss the legal world in the Cayman Islands. Special mention to Bobo 89.1 FM and DMS Broadcasting for providing radio services. Special thanks to Island Photo for my portrait that I use for advertising and promotion, and Impressions Hair Salon. First, let me remind listeners, if you have matters in court, please don't forget to check your dates so you will not miss your court dates. I also ask, please seek out a nonprofit organization, preferably nonprofits that involve children, women, and the elderly, and donate today to a nonprofit of your choice. Thank you again for being my very first guest, Laura Benades of the Truman Bodden Law School, and students Kimberly Russell and Velasca Borden Castillo, also of the Truman Bodden Law School. I think I will work on an interview with Mr. Truman Bodden next. If someone knows how I can contact him, please message. With me this evening is attorney Christine Bodden and Juliet Fenn of Quality Law. Hi, Juliet.
Hello.
Hi, Christine. Quality Law and Corporate Services is the correct name for the company. Christine will be speaking today, educating us in probate and letters of administration. Juliet over here will be sharing all about wills in the Cayman Islands. So I will let my guests go ahead and introduce themselves. Christine and Juliet, it's so nice to have you on the show with us today.
It's nice to be here, Patricia. Thank you for inviting us onto your show. We're happy to be one of the pioneering guests. Just to let you know, I guess, a little bit something about Quality, Quality Law Services, and Quality Corporate Services. Quality that's our short name, Quality, was established in 2017. We are a fully Caymanian-owned independent company. We offer both legal and corporate management services.
That's a great combination. I haven't found that too often.
Yes, thank you. And our services are offered to both local and offshore clients.
That's good to know. For our listeners who may be overseas.
Yes, so good evening, Juliet here. So I head up the corporate side of our company, and Christine, obviously as an attorney, does the law side. But I am also qualified in will writing and mediation, so I'm able to assist Christine with the preparation of the writing of the wills. So that's basically my role on the law side.
Okay, sounds good. So tell us where your company is located.
We are located at Cannon Place, that's in the industrial park area.
Formerly Merco Center?
Formerly the Merco Center, that's correct,
People
Patricia.
still call it Merco Center.
Yes, we are on the ground floor, conveniently located between V2 on one side. Is that a plug? Sorry.
So that is when you get into the parking, it's on the right-hand side.
Yes,
Okay,
that's
on the
correct.
ground
And
floor.
then Creative Tech is on the other side of us.
Okay,
Yes.
okay. And tell us a little bit about yourself, Christine.
Okay, I'll try and keep this as condensed as possible.
Yeah, just a short synopsis of who you are and your professional background.
Okay, I guess, well, on a personal level, yes, I'm a mother of one. I have a teen daughter. Hi, Hannah, because I'm pretty sure she'll be listening to this.
We hope so. And tell all of her friends her mom was on this show.
Exactly. I've been a qualified lawyer since 2006, being UK qualified first, and then from 2008, having then been called to the Cayman Bar.
Okay.
My practice areas generally are family, property, not specifically in this order.
Okay.
Family, property, wills and estates, some corporate matters. Mostly with the corporate matters, we also try to provide the services for local companies. So trade and business licensing, agreements, contracts, that sort of thing.
Okay. So you have a multitude of services under that umbrella.
Oh, yes, we do.
Yeah.
And, you know, we try really hard to offer a service that is for the residents as well.
Right. That's pretty much important when we think about today's Cayman atmosphere, where we've seen more local residents becoming more aware of their legal accessibility. So that's important to know. Juliet, we'd love to hear a little bit about you and your background.
Thank you. Well, I'm originally from Guernsey in the Channel Islands,
Okay.
offshore jurisdiction. I have been in corporate management for 40 years. Goodness. I have worked in Guernsey, I have worked in Gibraltar, and I have been in Cayman since 2005.
Okay. And you ladies do anything else with yourself besides work in the legal field? I mean, do you have any extracurriculars going on? Are you involved in any type of anything at all? Professionally?
Yeah.
Yes, I mean, I'm a very athletic person. Generally, I try to, my knees are pretty much gone now, but I was a runner for a long time. And so I try to stay fit by walking and, you know, running sporadically.
Right.
And, this is leading me to think a lot more about what I probably should, other things I should be doing. But I do try and get involved in the community as often as possible.
That is fantastic. I love to hear that.
Yes. So community projects, for instance, such as 100 Women of Cayman, which they recently had their girls' night out.
Okay.
Yeah.
You didn't invite me, but that's okay. Just kidding.
Yeah, and all of the causes were good, and you know, we got some really good charitable gains in for some organizations.
That's very important. What about you, Mr.
Well,
Juliet?
I'm more on the dramatic side.
Okay.
As a member of the Cayman Drama Society, I was
Okay.
their secretary for a couple of years. Primarily now, I sing with.
You sing?
Yes.
Wow,
So
check
I've just
you
finished
out.
the Jasmine concert.
Okay,
The
I
Spotlight
missed
on
that one.
Broadway. So, and we hopefully have another one coming up next November. So that's primarily what I do, and I play pickleball.
Oh, that's a new sport I'm just learning about. I did not know about pickleball until a few months ago, so I will have to check that out. So, jumping right into the swing of things now, I'm sure our listeners are anxious to hear about wills and trusts and probate and letters of administration. For me, this is a very important topic, especially when we consider the pandemic recently behind us, well, almost behind us. But more so, we've seen a significant amount of loss of loved ones, especially this year, and quite a number last year. And for me, I've realized that not many locals that I've spoken to or that have reached out to me are aware of how to do wills. Their loved ones may not have left a will. If they did leave a will, they weren't aware of what to do. They couldn't afford legal services to even do a consultation to find this information out. And I thought it would be very important to speak on this topic pretty early in my show. And I was glad that you ladies agreed to come on board pretty early. So let's pass it on to wills first with Juliet, which is where everything starts, right?
Yes.
Yes.
Okay, well, I guess it's really important to say what a will actually is.
Right.
And a last will and testament is a legal document that lets you decide what happens when you're with your estate after you die.
Right.
It's important to mention that you don't have to own property to make a will, and you don't have to be wealthy with lots of assets to leave to different people.
Right. So, sorry, I may interject here and there.
Mhm.
So you could have a car, or you can have clothes, or
Exactly.
any type of belongings, personal belongings or assets, no matter how minimal.
Exactly.
It's good to make a will if you want to make sure that goes to significant persons or
Correct.
places,
Yes,
right?
it's so that
Okay.
your directives are followed after you die, so you can
Right.
decide who you want to have your engagement ring or your
Right.
wedding ring, or, you know, simply if you haven't got anything at all,
Right.
whether you want to be buried or cremated.
Right, that's true, yes.
So, I mean, you can also have in your will where your pets are going to go. I mean, people forget about their pets.
Yes.
Also, in this digital age, your digital assets, like what happens with your Facebook account.
Yes, that's correct.
So
That's
you
absolutely
can,
true.
yeah, you can appoint a digital executor.
Right, okay. I was not aware of that. I am aware of Facebook particularly. They do give you the option to assign persons that can access
Yes.
your accounts, and can also allow you to decide whether you want your account to remain,
Yes, you can
active
memorialize your
or
account. Yeah.
delete it. So, but I was not aware in the context as you're expressing now, so that's good information to know, listeners.
Okay, so why would you make a will? So basically to save time, money and stress for your loved ones. You can determine who will manage your assets, who will be your executor.
Or there may be people who are not your loved ones who may decide
Exactly.
they want to
yes.
just
So
show up
you
out of
decide
nowhere
you
and wanna
decide who
access
gets your
whatever.
assets and your property
Absolutely.
and who doesn't.
Yes.
More importantly, you can choose who will take care of any minor children. So
Which
you
is
can
very
appoint your
important.
guardians.
Yes, I've seen cases where there were no wills and there were custody battles because that was not sorted out.
Yes, and the great saying, of course, is where there's a will, there's a family. This will lower the potential of any family disputes.
Right, that makes sense.
You can also support your favourite causes and leave a legacy to them.
Yes, donations. And
You can
right.
provide your funeral instructions, and it's very easy to make a will and gain peace of mind.
Yes.
So if you don't leave a will and you die intestate,
And sorry, can you explain intestate for our
intestate is
listeners? Yes.
basically dying without
Without a will.
having a will.
Yes.
So it's then the succession laws of Cayman. They are based on the principle of testamentary freedom. Now that means that you are free to leave your estate to anyone that you wish. However, if you die intestate, then the assets will be distributed in accordance with the applicable intestacy rules at the time. And this may not be what you want to happen.
Right.
So the Succession Act of 2021 revision, that contains the statutory rules as to the disposition of the intestate's estate to family members. So if you've got family members that you don't want to benefit, then you really need to leave a will.
Leave a will,
Otherwise,
yeah.
the law will take over and divide
your assets. So, Christine, I just want to make, not Christine, Julia, I just want to make sure while we're using legal terminologies, we're going to elaborate, kind of define it in a way for our average listeners to understand, and we're
Yes.
using, because we're legal-minded people, so we use that jargon pretty frequently and commonly. But I want my listeners and viewers to hear the legal terminology, but also for us to kind of give a definition of what it is. Okay, go ahead. Sorry.
That's okay. So, a well-drafted will can incorporate a trust,
Okay.
and that will take effect on your death, and it can be designed so that the trustees, who are the people that you're giving the power to under the will, they can hold your assets, your money for a particular person or persons, or for a specified period. So
Right.
if you have minor children, then the funds that you want to go to them can be placed into a trust.
Right.
Or if you have a child who is above age, he's over 18, but he's not very sensible with
Right,
the
right,
money.
yes.
You can say, well, I don't want him to get any of this
Right.
until he's 30 or he's 35. You can specify the age and the time that you want him to actually receive that inheritance.
So I've seen trusts also, just for discussion's sake, I've seen trusts also where, for instance, a person who's drafted a will and created a trust to care for their elderly parents, or, you know, just for any kind of allocation of those funds or the assets in that trust, in terms of even I've seen trusts where they have stocks and bonds and so forth, and it's set up where this can be distributed at this time, that time. I mean, are you aware of those sorts of trusts being set up, and all that can encompass, from my perspective, you can elaborate on this because you're the professional and the expertise here, but I just wanted to get a better understanding of any scenario that's possible for trusts. You know
Yes.
what I'm-
Yeah,
yes.
a trust doesn't have to be basically monetary. So your trust you can be setting up for education
Right.
purposes for your children.
Yes.
So whatever assets that you have, if you want to leave them to somebody that doesn't have control over them, then the trust element would come into play then. But
Perfect.
it's also important to note that that trust won't come into effect until you die.
Right.
So, you know, it's not set in stone that this is what's going to happen. You
Right.
can change your will. You know, once you've made it, if things change, your circumstances change, it is easy,
To
an
change
easy
it.
process to change it.
And so once someone is wanting to create a will, can they write a will on their own, or does it have to take a legal person? What does it take to well,
You
go ahead.
can write your own will, absolutely. The only time that you're going to get into difficulty is when you're no longer here and you haven't drafted it correctly.
Right,
Therefore,
yes.
you know, it may not be valid.
Okay.
So, you know, there's nothing wrong with drafting your own will and then getting somebody legal to look over it to see whether you have, you know, met the criteria.
Right. So what would a will look like under Cayman's laws in terms of the legal elements for it to say it's a will?
Yes.
You
Okay.
know.
Well, basically, you have to be over 18
Okay.
to make a will.
That's important.
The will needs to be signed by two witnesses who
Okay.
are there together.
Right. And who are of sound mind and body.
Exactly. You also have to be of sound
Yeah.
mind to make your will. But those, the persons that are witnessing your will cannot be beneficiaries of that will. They can be the executor,
Right.
but they cannot be beneficiaries.
And for the sake of our listeners, what's an executor?
The executor is the person that you are putting in charge of your will,
Okay.
and then when you die.
Okay. Who reads the will and make sure that your wishes are honored.
And they distribute all your assets for
Okay.
you.
Yeah. Which will be covered when
Yeah,
we
when we
to
get to the
Yes,
probate.
yes, I'm getting ahead of myself. It's exciting stuff, so.
Yeah.
Yes.
Oh, that's good.
The
Yes,
will
yes.
also has to be in writing. That's important.
Right.
And an electronic copy does not suffice. You
Okay.
have to have a written, signed copy.
Okay. So someone could write it by their hand and have it witnessed,
Yes.
but they could also type it up on Word, for instance.
Yes.
But print it out and have it
Yes,
signed.
it must be a printed and originally signed
Hard copy. Okay.
Yeah.
Okay, and what else can you tell us? Is there any particular elements under the Cayman Islands laws that we have to follow in terms of not only the structure, but how to document it? If you want to document it, to make sure that, say for instance, if I have drafted a will, whether by hand or otherwise, is there a process, do I just keep it at home in my drawer, or is there a process where I have to go and file it with the general registry or the courts, or?
No, you can keep it at home, but you should certainly let your family know, where it is.
Right.
Or you can leave it with your lawyer, or whoever is going to be your executor. I would also have more than one copy.
One copy, yes.
Yeah.
Yes.
So the original is probably a good idea to keep it in a safe.
Right. I was just
Especially
thinking
during
that.
hurricane season, in a plastic bag within
Don't
your
tell
safe.
your children.
But I think also it's important to note the changes that have come in for wills in Cayman.
Very important.
The healthcare directives is an important one.
Right.
So the Healthcare Decisions Act, 2022 revision, that came into effect in 2019.
Okay.
And this allows you to express your wishes in regards to the forms of medical treatment that you wish to be provided or
Yes.
not provided,
Not provided, yeah.
in the event of terminal or very serious illness.
Okay, okay.
Within that, you can cover your end-of-life care, whether you wish to be put on long-term life support or whether you wish to be resuscitated in the event that you stop breathing.
Okay.
So to take effect, that directive must be witnessed by 2 individuals, including a doctor.
Oh,
Because the doctor is certifying your mental capacity to make these decisions, and the doctor will have gone over with you the consequences of choosing, not to be resuscitated. While it might sound obvious, it's one of those decisions that is easy to say, I don't want to be resuscitated.
yes.
But
yes.
you really need to understand what that means.
That means exactly.
So I've never been resuscitated, but I understand it can be quite a painful process. But also, if you're resuscitated, what is going to be the quality of your life? Are you going to be resuscitated and put onto long-term life support? You really want to be free to make those decisions. However, if you don't, you'll be resuscitated, but as soon as you lose that mental capacity
Right,
to make
yes.
those decisions, you can choose for somebody to make those decisions for you.
Right.
If you haven't done that, then the doctor takes over and makes those decisions for you.
Okay. Okay.
So I think that's
And
important.
a lot of loved ones may not
Yeah.
want that,
Exactly.
They want to have a say in that significant person's care.
Yeah.
And health decisions, whatever those may be. Have you found that you have a significant amount of clients that are interested in these services?
I think it's still relatively new, and I
yes.
don't think that a lot of people know that that is something that you can do right now.
Yes,
Because
I
it's-
think for Cayman, historically, our people are not as, we have not given enough attention, is what I wanna say, to these types of very important, things to consider in our everyday life, and all of a sudden when someone becomes ill or something happens, and there's a scramble to figure things out, or there's a scramble to, okay, I need to write a will. I need to make sure my family is taken care of, my children, my pets, my mom, my dad, there's been people who have been unwell. Unfortunately and regrettably, there's been a significant amount, and I love that word, amount of persons who you would have not thought would have been ill or,
Yes.
and they passed away, and nothing was in place. So this is why I think it's important to have us have this talk. And you can share a bit more what you have to share in terms of will, because we need to get this out there.
Yes.
And we need to have people running to your office and wanting to write wills.
Yes, indeed.
And we
I
need to
think
have
it's-
you guys
Yeah.
helping these people, I shouldn't say this, but making it affordable.
Yeah.
You know, because not only have we gotten into the legal field to offer this service, but also to offer this service in order to serve the society, to make sure these services are accessible, you
Yes.
know? So I know I keep interrupting you, but
That's all right.
we're having a conversation.
Yeah, I think it's important too that, to note that if you don't make your will early,
Right,
you run the risk of getting to that point where you're either very elderly and infirm, and then the family are saying to you, hey mum, have you made a will?
right, yes.
Mum, I think you need to make a will. Well, who am I gonna leave it to,
Yes.
says old lady, and oh, well mum, I think you should leave it to me.
Yeah.
I'll look after everybody, mum,
Right.
leave it all to me and I'll sort it. Well, we all know in reality, once some people get hold of money, that's their money.
Absolutely.
So, it is important, if you've got something that you want to go to somebody in particular, then make your will.
Now, here's a quick question, I'm not sure if it's yours or for Christine, but I know the difference between a will and a power of attorney, but how, just for argument's sake, how does a power of attorney kind of play into certain things where we're kind of crossing over, a power of attorney for someone who's alive, right?
Yes,
And,
they have to be alive.
You wanna leave that
Mhm.
question for you, Christine?
I'm happy to answer that at this moment right now.
Okay.
A power of attorney requires that the individual granting the power has capacity.
Right.
In addition to the person that will receive the power, they should have capacity obviously as well.
And that
So-
power is to act on behalf of,
while they are alive.
right, okay.
Yes, so while they are alive, and it's important to note that if that individual, the grantor, or the person who grants the power, if they lose capacity, not necessarily that they die, but if they
Right.
lose capacity, then that power falls away.
Okay.
So that is important to note as well, because many people, and we've had potential clients come to us and say, oh, they need a power of attorney. First question is, does the individual have capacity? Because sometimes people mistakenly believe that the power of attorney can be for their loved one that's already lost
Already
capacity.
passed, yeah, okay,
That
that's
has-
lost capacity.
Exactly,
Okay,
has
okay.
already lost capacity. And that in-law,
Mhm.
and the practicality of it is that cannot work,
Right.
because the person does not have the legal capacity, the mental capacity, to then grant
That authority.
that authority.
Okay, that power, okay. And so, Juliet, what else can you tell us, or do you want to tell us? Because, it's very important for our listeners to know as much as they can know. I know it'll get into more legal stuff, but that's fine.
Yeah.
Just, if we can swishy-swashy and explain the legal stuff, but let's get into the nitty-gritty
Yeah,
if we
I
can.
think it's important to leave the legal side of it to the attorneys.
Right.
And basically to decide what you want to happen when you die, or in the medical directive before you die. But it's important, I think, to finish with knowing that you don't have to be wealthy to have a will, you just have to have something that you want to go to someone else.
Yes.
And in order to make that happen, you need to have it documented.
Right.
You can do it yourself, it's very simple, as long as you follow the rules to make sure that it's a valid will.
Right. And well, for me, to be honest, I would advise anyone to consult an attorney, not because I wanna send people to an attorney, but because I think if they want to make sure, like you said, that everything goes according to how they would like it to go, they've passed away peacefully, anyway, they've passed away, and with comfort and peace of mind, knowing
Yes.
I have done this the right way, and my wishes will be honored, or should be honored, by my loved ones, or those, my caregivers, or whoever, I say that people should consult an attorney. You guys are the professionals, you know how to draft it, you know how to word it, you know how to make sure that everything is covered, even if someone may not think about something, you know, they may have forgotten. I know a lot of people these days don't even wanna put their monies in the banks.
Yes.
And I've heard people say, I'm gonna put it in a jar, and they may forget that jar. You know, you as attorneys can say, hey, do you have any monies laying around somewhere? Do you have, you know, whatever it may be.
Yeah.
You as the attorneys can jog that person, trigger that person to say, hey, yes, I just remember I have this, I have these books, you know, I want to allocate these to, you know, certain, wherever. So I do think it's very important to consult an attorney, to get a will drafted, and I want to encourage my listeners to seriously consider getting a will drafted, or encourage your loved ones or friends and families to get a will drafted. It doesn't matter how old you are, as Juliet
you're over
said,
18.
as long as you become 18, parents, if your children are turning 18 and, you know, they may have a car, anything. We've seen, unfortunately, a lot of young people also recently passing away, and, you know, I want to encourage parents to have them get a will, you know, because they've started working, a lot of young people have made investments even at 18, 20, 25, and they have no will. So that's important also for our young listeners. Think about getting a will. Parents, grandparents, encourage your grandkids and children to consider getting a will. I'm going to turn it over to Miss Christine Bodden.
Can I just interject one thing first?
Yes, go
And I think
ahead.
it's important to just clarify that I'm not an attorney, but I am qualified will writer.
Okay, and what's
So-
the difference?
Well, I'm not an attorney, so I haven't been to law school,
Right.
but I have taken a very in-depth certified course
Okay,
for will writing specifically.
okay. So in the
So-
Cayman Islands, that's valid?
Well, I'm in the very fortunate position that
Okay.
I have an attorney as my partner.
Oh, okay, I see
So-
what you're saying, so she signs off.
I can draft it
Mhm.
and everything else. I can have the discussions
Okay.
with the people, and that keeps your costs down.
Right, that's
So
true.
if you go to an attorney first, you know,
Yes.
then
You're paying attorney
you're
fees.
paying for them to take all your instructions and everything else. Whereas if you
Right.
come to quality, you can get it done by a non-lawyer,
Right.
knowing and being having the confidence that it is being reviewed
Right.
by an attorney.
Well, that's very important for our listeners to know. That's more incentive to seek your services, because everyone is always looking for cost-effective services. Christine, take it away.
Thank you, Patricia. And thank you, Jules, for highlighting the importance of wills. And again, also by putting it out there to the public as to how Quality can assist individuals with getting their wills and estates in order. So, I'm gonna discuss probate and administration.
Right,
Because the practicality of it is that having the will is one thing.
right.
Sometimes not having the will is
Is
another.
another thing, yes.
But it doesn't stop there. There is a process that individuals, or that the deceased or their executors will have to go through, which includes filing documents with the courts,
Okay.
so that they are legally entitled to administer or distribute the estate.
And this is just to be clear, despite having a will, in addition to having a will, in the Cayman Islands, that will still has to be probated.
That's correct.
Okay.
Yes, that's correct. So.
Because I've found, sorry, Christine,
That's
I've
okay.
found that a significant amount of people that have spoken to me was not aware of that. They think because there's a will, if there has been one, okay, everything is fine, you know, we don't have to worry about anything. And I know that that's not so.
Yes, that's correct, and that's a very good point to raise. We've had clients come through and, the same thing, they weren't aware that there was that, you know, obviously
Next
we
step.
didn't write that will
Yes.
because then they
Right.
would have been advised, obviously.
Yeah.
But, but there are those next steps that we
Yeah.
need to discuss and be aware of. So, what is probate and administration? Essentially, it's the production of a legal document issued by the courts where a judge then is satisfied that a person, or in some cases an organization, should be permitted to deal with the deceased estate.
Okay.
So I'm just
okay.
trying to make this in layman terms, so that people understand that the buck doesn't stop with just the will.
Right, yes.
They do have to then go through this other process, and this is where sometimes people, if they have drafted their own will, and you know, good for them if they have, which is great.
Yes.
They may find it very helpful
Yes.
to
yes.
then seek legal services
Okay.
to take it to that next step.
So let me ask you now, if a person wants to probate, my loved one has passed and I have a will, I come to you for the services, you can take on the responsibility to take this matter to court for me and have the court probated, or is it something I can walk into the courts and do on my own, or?
Oh, certainly. An individual who, you know, if they feel that they can deal with that aspect of it themselves, sure they
tedious
can.
aspect.
Yeah, but there are a lot of tasks
Yes, and technicalities.
and technicalities involved. So I'm gonna run through that. So we
Okay.
know that if there was a will left behind, then
Okay.
it's a grant of probate. That's that legal document that I mentioned.
Right.
And if there wasn't a will, then as Juliet mentioned, you know, the individual would have died intestate.
Right.
So that's what
Without
that
a will.
means.
Mhm.
And then what that individual has to seek is letters of administration.
Okay.
So that means, so basically there's probate if there's a will,
Right.
and there's letters of administration if there isn't a will.
Okay.
And so when I spoke to that legal document,
Right.
it's one or the other depending on the state of the affairs,
Right.
yeah, of the
person's
deceased. Yeah.
estate.
Yes,
Yes,
exactly.
yes.
Um,
And sorry, for the sake of our listeners, estate would mean basically whatever that was yours and you passed on and
Oh,
left
yes,
behind.
yes,
right?
any assets, it could
Yes.
be money, it could be,
Doesn't
jewelry,
necessarily
it could
mean
be.
property, like real estate
No.
property or anything, just wanna
No.
be clear on that,
Yes,
yes, okay.
yes. So probate and administration is governed by the Succession Act, and also the probate and administration rules.
Okay,
So there's the act to consider, and then there's also rules. The
Okay.
rules tell you, for instance, speaks to the time limit.
okay,
A lot of people don't realize that there is a time limit to apply to the courts for either probate or letters of administration.
okay.
And that time limit is 6 months after the deceased,
Has
after
passed.
passing.
Yes,
Yes,
okay.
of the deceased.
Hear that, listeners? 6 months after the deceased has passed.
Yes, it does not mean that, it doesn't mean that the loved one or if in the case of a will, the executor
Right,
will be barred from doing it. That's not what it means at all. It just means that past 6 months, you then have to apply to the courts, for the judge to decide an application for special leave, which is basically special permission
right.
to file these, whether it be probate or letters of administration application out of time.
Okay, okay. At least there's provisions for that, it's not a cut in stone, 6 months, that's
Oh,
it.
no, yeah.
You know, because we have to give people time to grieve and so forth, you know, and find out what the process is, because after 2 or 3 months, maybe even a month, some people have started to scramble. Okay, well, I gotta get my loved ones or whoever affairs in order, you know, so that is a reasonable time, those 6 months, and like you said, there can be an application to the courts for extended time, so that's good.
Exactly. Thank you, Patricia. So is a grant of probate or administration necessary? Yes. As
Yes.
you know, you rightfully asked that question earlier on. It is necessary to administer the estate of the deceased.
Okay.
Now, there are some situations where, for instance, if there was just one child and that person, or it was just the wife and no children, and essentially that individual's name was also on every other account, and you know, sometimes in that situation you'll find that if there wasn't a will, they may not necessarily have to go and apply for letters of administration because no one else is being affected.
Right.
But that's still a risk because sometimes you might have people pop up.
Right, yes.
That you just didn't
Yes,
know about.
did not
Yeah.
know about, yes, and people that think they have rights to
Exactly.
you know.
Exactly.
Yes.
So really the cement is to go through the proper legal channels and just to ensure then that, for instance, the organizations holding money or assets that the that individual is actually the correct person and the only person that should receive anything from that.
And also too, for me, what I have found is that it's important to do this process also because sometimes there are assets or other estatable items that come out in these proceedings, you know, where you may not have known your loved one had,
That's correct.
you
That's
know,
a very
certain
good point.
assets or access to certain things. So I've seen that happen too, which is another important reason to go through that the law provides to go through this process, because I've seen where people have discovered there were overseas accounts, overseas property. You know, they had a brother overseas, or, you know, that sort of thing that they never knew about.
Yes, I mean, that's so true because, I mean, life happens and then
Yes.
sometimes people pop up out of the woodworks,
Yes, yes.
right? But, so who's entitled to make this application? For a will, the executor. If there hasn't been an executor assigned, often it's just another family member that's aware of the will. And then that individual on probate could be applying to essentially become the executor.
So executor and administrator, they're two different persons, right?
Yeah, because it's two different functions.
Yeah.
So the administrator is when there is no will,
Okay.
and the executor is when there has been a will and an executor has been named in the will usually.
Right. So
That executor could either be, it could be a family member, it could be a friend, it could be the law firm.
Right. Right.
Yeah,
Okay.
yeah.
And I'm sorry, I've seen cases where the courts have stepped in and became executors. I've seen two cases where that happened, where the court stepped in because of a minor child.
Yes,
Not
yes.
of a
that
will,
can happen.
and the court stepped in and, you know, the parent unfortunately passed under tragic circumstances, and, it was aware that the parent had assets, and they stepped in and were, you know, you guys know about these things, so I'll let you get on with your.
Yeah. Okay, thanks. So when there's no will, and then the law sets out who's entitled by an order of priority, this would apply to letters of administration.
Okay.
So whereas with a will, it's usually clearly defined who is going to distribute the assets, the estate, right? That's the executor.
Okay.
But you're not gonna have that benefit when it's when it's that the individual did not leave a will behind.
Okay.
And then you have to apply for letters of administration.
Okay.
Right? The law prescribes for a priority in terms of an order in which people are given the entitlement to apply.
Okay.
So for instance, the wife or the husband, so the spouse would be the first individual that would be entitled to make the application. If the deceased was divorced, then that falls to the children.
Oh, okay.
Yes, divorced and not
Right.
remarried.
Right.
you'd be surprised, sometimes you have to check to make sure
Yeah,
that
that-
there's an actual decree in place.
Right,
Because
yes.
then that's a very good example as to when you might have someone just pop up out of the woodworks.
Right, yeah.
And then say, oh, hey, that
That was my
never
spouse,
final,
yes,
even if they were estranged.
yeah, yes.
And
Sometimes loved ones don't even know that either, you know, that nothing was final.
yes.
Until this comes up.
Until
yes.
this comes up
Yeah.
as well, exactly. And then, the children, you know, and then it goes on after that, so then it could be full siblings would be the next priority.
Okay.
And if there aren't any full siblings that will come forward to make the application, then it could be then they consider half siblings. And so there is, the law
There's a
prescribes.
distinction
Yes,
between
the
half
law,
and whole oh,
yes,
wow.
so the law does prescribe for an order of priority.
Okay.
And so those are the nuances basically
That
that.
is very interesting to
That's,
know because.
and it's important to know
Yes,
because it
yes.
could make the difference between an application, failing or not.
Right, yes. And what about, what about siblings of the deceased?
Yes,
Is there, okay.
yes. So that's where it could be detrimental to know. If it falls down the line.
Right.
And it has to be a sibling of the deceased that's making the application, yes, their priority is lower.
Okay.
Lower compared to the
compared
wife
to the children and the wife.
and the children.
Or the
Yeah.
husband, okay.
Or the spouse generally.
Yeah. That's important to know.
So we've discussed the time limit, you know, bringing that back, that's the
Yeah.
6 months.
Yeah.
And, permission of the courts needs to be granted for certain within those 6 months.
Right,
Or special leave, special permission,
right, okay.
needs to be applied for through the courts.
And this is all through the grand course, because I've had people approach me and saying, why does it cost so much?
Mhm.
You know, thinking that it could go to summary court the same as a criminal or traffic matter, and I don't think people understand the reasoning behind it having to go to a higher tier, I call it a higher tier court, in order to, you could explain
Yeah,
that.
in order to ensure that, for one, like the proper person has
Right.
come forward
Right.
to make an application, whether it be for probate or for letters of administration. And, you know, it is quite a significant thing to have someone in charge
Yes,
of your estate after you've passed
Yes,
away.
yes.
You no longer have a say, so, rightfully so, the judge, then has to be satisfied
right.
that the
yeah.
criteria is met.
Met,
within the
okay.
law. But having said that, at the same time, if with regards to small estates, like very, very, like
Small.
nominal
Right, right.
estates, if the public, I think it's good for the public to know that they can also look on the judicial website.
All right, yes.
Right, and they do have a
Judicial.py.
section, exactly, they do
Yes.
have a section that actually speaks to small estates and how
Okay.
that can also be handled.
Okay.
So, in the probate and administration rules as amended, that's basically where you can find, if, for the individual who wants to make this application on their own, or attempt to do that first without seeking, legal expertise,
Okay.
they could also refer to those rules. And it does set out, templates. I think people usually find out that that the templates are great.
Yes, yes.
But then there are other.
Other things that has to go into the
exactly.
document too, that is, has to take a legal person to insert.
Exactly,
If it's very, very simple, yes, because we have a lot of people, unfortunately, who really don't have much, you know? But that template really takes a legal person, because there's many other things that has to get
Exactly. And
inserted
even-
into this
does,
document to
and-
make it valid and cover everything that you know you want to cover before anything
Yes,
happens.
I think it's important to say that, you don't know what you don't know.
Right.
Yes.
And
Right.
that's where the legal element comes in. I
Right.
mean, there are certain instances that, for instance, one is where, a chap had got himself a life insurance policy and he'd named his wife as the beneficiary. He then divorced, got remarried. He'd made his will thinking that he'd left everything to his new wife. But of course his life insurance policy hadn't been changed.
Yes.
So his first wife got the proceeds of his life insurance. And those are the sort of things that you don't think about.
Right.
So this is where, Christine as the expert here will, point everybody in the right direction to
And
make sure that
even
everything's covered.
Even the very wealthy don't think about those
No,
things.
that's right.
And they have the means to consult, and they never do.
Yeah.
So it's very important that whenever there's a life-changing event, a new baby, a new wife, a new husband, someone goes off to college, different things, there may be a grandchild, something life-changing, you've opened a new, you started pension, you started a new life insurance, those sorts of things. It's important that you consult legal services to make sure that everything is up to date and everything has been changed, because as we say here in Cayman, that person could be rolling over in their grave because, thinking, of course we know they're not thinking, but thinking, I forgot to change my beneficiary, and your loved ones that are left behind is thinking, why didn't we think of that? Why didn't mommy or daddy think of that? So it's very important, listeners, that you do seek legal services, first to get a will, but also when there's a life-changing event of any kind, no matter how much happiness it brings you, to make sure your wishes are always on record and honored. When you change jobs and you want to change your beneficiaries on your pension, on your new job, those sort of things, all of that stuff goes into considering with your will.
Yes, thank you, Patricia. And also because it is quite important to just, in law we call this a codicil.
Okay.
So if you're gonna make a change, then even if an individual has drafted their own will, and they want to bring it to us just to have a view of it, and the will is fine, and then they want to change it, then they may not know how to make that change.
Make those changes.
And it is, as Juliet mentioned, it's quite, it's not that arduous to do. It's a codicil, and it's just basically says what the change is, and it will override what was in the previous will. And sometimes it's a half a pager.
Right, yes. And I've seen a situation where I've actually seen 3 situations like this in Cayman, where persons gave persons permission to reside on their property or use their property. And they may have given a letter of permission, or they may have verbally gave permission, and then they passed and they didn't put this permission in the will, and now the persons that are on those properties or using those properties are left, for lack of a better way of saying it, high and dry. And that becomes a legal issue for the person that is utilizing the properties, but also for the families that the properties have been willed to.
Yes.
So that's another important thing for us to think about when we're drafting these wills.
Yes.
Yes.
And then also with, it's interesting that you mentioned about pension.
Right.
Because that's one area.
Yes.
Where it's not necessarily going to be governed by the will. So for instance, if a married couple did not complete their divorce in time, before one of the spouses passed away, the pension will still automatically go to the surviving spouse.
Oh my goodness.
Even if on their deathbed they had not been together for 20 years. But if that divorce decree was not issued and the divorce was not finalized, then that pension will become the benefit of the surviving spouse. And that's under the pension law.
I think it's important for you to repeat that again, Christine, please, because we know right now in the atmosphere in Cayman, pensions is a big issue right now. There's been some changes to the pension laws since the pandemic, and we've recently I've recently been aware that there's more changes coming. There's a recent motion passed in the House, and there are more changes coming. So that's something I think is important for you to repeat, so people can be aware. we've seen a lot of different shuffling with relationships and family dynamics and so forth in Cayman also over the last 3 years due to the pandemic and, you know, whatever.
Yeah, and those aren't happy situations, but the practicalities.
Right.
Can be quite detrimental just to a family situation.
Absolutely.
Financially.
Yes, definitely.
If the affairs weren't properly concluded.
Right.
Like
I
for,
agree.
you know, for a divorce.
Right, yes.
Prior to the deceased.
Yes.
passing, yeah.
Okay, and, moving forward with what you have.
Okay, so basically for an application, this is just gonna be some practical suggestions.
Right.
And not just suggestions actually, but what's also required in accordance with the rules.
Right.
When you're making either an application for probate or an application for letters of administration, you know, you might wonder what documents must be submitted with the application. So when we're speaking about wills, then you must attach the death certificate,
Okay.
right? And this is just some practical stuff for the
Right.
person, the lay person out there, who,
That's important.
if it can help them,
Yes.
and they're going to make this application on their
Yes.
own. It has to be either an original or certified copy, you know, certified by a notary as such.
Right. And that can be
And the
obtained from the general registry.
Yes, that's correct.
If they passed in the Cayman Islands.
And they need to get yes, exactly. Then.
Sorry, but if they obtain your services, that's something you guys would do as the attorneys representing the party?
We could assist with that, but normally our clients will come to us with
Prepared
the
those
will in
documents.
hand.
Okay,
Yeah, with the death certificate in hand.
okay.
The will also has to be attached to the application, and
Okay.
again, this is for probate
Right,
applications. And the will must be marked, so there are, you know, so many different
Elements. of it,
elements and
yes.
jargon that, you know, I'm gonna put out there and
Right.
other lawyers and professionals will know.
Yes.
But the average person may
Person will
not,
not know,
so
yes.
that's also the benefit of coming
Yeah,
to
legal,
to
yes.
us as
Yes.
professionals, yes. So where there has been no will and the individual dies intestate, then the application must include the death certificate, again, either the original or this one that's certified as a true copy. And then, a lot of people don't realize, but then a declaration of a bond needs to be. Now, I'm just gonna take a moment to explain that, because this is an additional
Okay.
sort of
okay.
arduous task.
Okay.
Because basically that bond needs to be, for at least 2 times of the value of the estate. So
Oh.
basically, you've got to then, the applicant needs to find an individual
Mm-hmm.
that will, assist them,
Okay,
as a guarantee.
okay. So what are they guaranteeing now?
That,
I was,
that
I
essentially.
kinda got lost right in there somewhere.
Yeah, that, essentially, if it doesn't get administered
Okay.
as it should.
So when we go to
Then-
court and if it doesn't work out how people think it's gonna work out, is what you're saying?
Right, there has to be some way of providing
Okay,
money
For- for-
the
for-
assets, yeah,
okay,
right, so it's
give me-
it's
give me
somebody
a-
that's going to
Mhm.
support them enough, or knows that they have the integrity, the honesty as well.
so if I come to you and say this is my situation, my loved one has passed, and you say, okay, with a will, we can probate this, with a will, we can apply for letters of administration, and then we go to court, and what's this bond for now?
Yes, this is only for letters of administration.
Okay, so without.
So it's
will.
kind of like a security.
Right, so you have to find someone
Yes,
that will put up a bond in the value of,
at least
potential
twice
value,
the value.
twice the value
Yeah.
of what we
Of-
think the estate may be worth,
Correct.
right? And what's the purpose of that again? I'm sorry, cause that's
Um,
new to me.
Yes, and I guess, you know, it does make sense because there is no will.
Right, okay, I see what you're saying.
Right, when
yes.
there's a will in place, you know what you're dealing with, you know that XYZ
Right,
exists,
right.
and,
Guys, this is why it's very important to have a will, because very rarely are you going to find someone that has twice the value of someone's estate to be able to help you bond the situation.
Exactly. And then there's also an affidavit that has to, be attached to the application.
Okay,
That affidavit is basically the applicant swearing, as to their entitlement.
okay,
You know, why are they the ones making the
okay,
application?
okay,
And again, this applies to letters of administration, so then there is an order of priority that is prescribed by this law. So the probate and administration rules and the Succession Act, right? And so that basically says, again, spouse first, children, and so forth and so forth, yeah. And so, yes, that is an affidavit that's then filed with the application. There is actually stamp duty to also consider, because.
Who pays that?
Exactly, it's quite nominal, so
Yes.
it's not too tricky there.
So this is sort of like a tax to the
Yeah.
courts to have this done, right?
Yes, and it's with filing the affidavit, for instance.
Right, okay,
So it may be like $1.50
okay.
to, stamp has to be then
Oh, I see what
affixed
you're saying, yes.
on that
yes. Okay.
to that affidavit.
It was like
And then
stamp
it's
duty
filed
like
in
a
the
house,
courts.
I'm kidding.
Yeah, nothing too arduous. So again, with what costs are involved, well, I just spoke to stamp duty. Generally, there are quite a few fees involved.
Okay,
I would then say that I would direct people
okay,
to the court website
okay.
for the
Judicial.ky.
fees. Yeah, just for confirmation of the fees. I don't
Yes.
want to misquote any fees
Right.
there.
That's
Really
important,
person.
we like to know beforehand what these fees are going to be, because everybody's trying to, curb spending. But
Yeah.
we also want to make sure everything is in order in our affairs.
Exactly, but it is affordable for the individual who wants to take that task on their own.
Okay,
At least in cost, it's affordable, but there are, like we've mentioned, there are other issues
right, okay,
that could become problematic later. And where are these applications filed? These applications are filed at the courthouse.
okay,
That would be, the Kirk House Building,
right,
the Civil Registry,
okay.
yeah, which is upstairs, on the 3rd floor, I believe, yes.
Yes.
Need to remind myself sometimes.
Yes, because the courts have been expanding, which is a really good thing. So happy to see that happening, but back to you, Christine.
Thanks, Patricia. So what happens after the applications have been filed? And when I say applications, I'm just gonna take a moment to define that, because I'm referring again to either probate or letters of administration.
Okay,
So once those applications have been filed, then a notice actually is posted at the courthouse.
right, on the ground floor.
On the ground floor,
Okay.
exactly, and that is, the purpose of doing that is to allow for any individuals who could potentially contest
Right, right.
an application.
And or be aware that.
Or so
you
that
know,
they are aware
right,
of.
that the estate is going through
Exactly,
that process.
exactly. And then, there's also advertising that takes place in the Gazette.
Okay, okay,
Exactly, so there are 2 mediums by which, such applications are then put out to the public. And then there's an opportunity for members of the public who might have some association.
right, for whatever reason.
For whatever
Yeah.
reason to come forward.
Okay,
Right, so that process can sometimes take, I believe, about 6 weeks.
right, okay, I was going to ask that question.
Yeah.
Yes.
Yeah. So not to be startled if when you make your application, file that initial application, you don't hear back from the courts right away.
For
They're
a
in the
while.
background doing their
Yes,
jobs
there's a
to
process
try
to
and
go
get.
through.
Exactly.
And a certain period of time for noticing. It says if when you're getting married, you have to post that notice there in the court's office. You have to post a notice, and it has a certain time frame for the public to know you're getting married. It's similar to that process, listeners.
Exactly, exactly. Thank you, Patricia. So, as mentioned, it's just in order to give notice to anyone wishing to show a cause
Right.
against a particular application
Okay.
as well. And then there's a caveat that we could discuss
Okay.
as well. This ties into this potential individual that could
Come out of the woodwork.
contest, right?
Yeah.
So sometimes you'll have an individual that has a priority. For instance, with filing letters of administration,
Right.
and they'll file caveats, and that's sometimes to give them an opportunity to look into whether or not somebody else who's
Yeah.
claiming
Right.
that they have a cause in the
Right.
matter.
Okay.
It sort of will stop them.
Right.
It'll stop others from filing
Okay.
letters of administration in the
Against the estate.
against the estate during that period.
Okay. Okay.
Yeah. So what happens after the application is published? Well, once everything comes back clear, then the application will go before a judge,
Okay.
and the judge basically administratively is how that's dealt with. The judge then decides whether the application satisfies the requirements under the law.
Laws, yes.
And when I say the law, I mean primarily under the Succession Act and the Probate and Administration rules. So once the judge determines that the requirements have been satisfied, then a grant of either probate or letters of administration, depending on which one was applied for,
Okay.
is then granted.
Okay.
And
And the parties are notified?
Yes, so they would be notified, if it's through their lawyer, then the lawyer would notify them, because then they would have received the sealed documents from the courts.
Okay.
If it's an individual that has dealt with it on their own, they may want to keep going to check back with the courts, for that.
Okay.
And, what is the responsibility of the applicant after receiving a grant of probate?
Yes, I was just going to ask that question. What happens next?
Or letters of administration?
Yes.
Well, that's when the real work also starts, with distribution. So distribution of the estate,
Okay.
either in accordance with the will. There's huge responsibilities there on the part of the executor
Right.
to
Right,
ensure that, for instance, they have a proper inventory, which also has to be filed by the courts, filed with the court, sorry. And, to ensure that they are distributing the estate in accordance with the law
Yeah.
and the will.
Okay.
Distribution must take place usually within 1 year.
Okay.
Sometimes, life happens in terms of you may not be able to find certain individuals and that sort of thing. Put best efforts forward as the executor, of course, and then, you have a year to work with, so that usually works out. And I'm sure there are instances where not able to meet the year, that
Right.
happens
Yes.
too.
Because you may have people, like you said, overseas in other countries, and, they have to be found, they have to be
Exactly.
included.
Yeah, sometimes we become detectives too,
Yeah.
just to find
Yes,
some of
find
these
these people,
beneficiaries, And then accounts also have to be, prepared
Okay.
and then filed with the courts, and receipts and that sort of thing, just to, make concrete that the distributions took place.
And this includes notifying, places where there are assets, like land and registry, banks, and, wherever assets may be held. Is that also included?
Well, yes, cause
Is that a service?
eventually, if there's going to be, a transfer
Right,
for the land, for
Right.
instance, that's left to a loved one,
right.
then you will have to provide, a grant of probate or letters of administration.
Okay, to those
To the-
institutions
yeah.
and businesses, okay.
Exactly.
So a person could take that document and go to credit union or go to the banks and say, hey, this is.
Or lands and
this
survey.
is- Yes.
Yes.
Okay, okay.
Yes.
That's important to know.
That's very important to know, because that ties in with the entitlement
Right, okay.
and the reasons why you must,
Right.
apply.
So you
for-
can't just take a death certificate to these places and say, hey, I'm a beneficiary. I mean, some may accept it just to show that the person is passed, but this document through the courts is the
Right, because
the
it's-
document.
Correct, it's legitimizing the transfer
Right.
from the deceased
Right.
to
the beneficiary.
that beneficiary.
Okay.
Yeah.
So, we're just gonna have Christine give her final few points here. So, this has been a really, really interesting discussion. We have got to have you guys. This is so
Thank you.
interesting.
Right.
Myself, I've learned a lot. Trust me on that one.
And so just to close, as one of the last responsibilities, and it's quite a significant one,
Right.
of the applicant for either a probate or letters of administration, is that when the accounts are filed, that will be open to inspection by beneficiaries. So that's also a good checks and balance,
Okay.
just to ensure that, the assets, the estate was distributed, appropriately.
Okay.
Thank you.
I hope my listeners have learned a lot from this show. And Christine Bodden and Juliet Fenn, any final closing words?
Yeah, I think from my point of view, I think it's important to let the listeners know that we are able to do a home visit for your wills. So, elderly mum and dad don't have to get into the
Or
car
living out in the
and
Eastern District.
calm down, yeah. And also that if you have, your elderly relative or you yourself, if you're elderly, if you're dependent on one person bringing you into town, you may be receiving some undue influence there and some coercion, and
Right.
they know everything that's going on.
Right.
So for us to do a home visit means that we can talk to you by yourself
Right.
and know that there's no
Uninfluenced.
undue influence there.
Very important. Juliet, thank you for
Yes.
that. Christine?
Nothing further to add.
Thank you. I wanted everyone to know again, let me ask this very important question. Is it possible for any potential clients to receive maybe a 10-minute free phone consultation just to see what your services are about and if you're able to help them? Is that possible?
We have actually been talking about having an open office day on certain projects, and wills will be
Okay.
one of those
That
topics.
is great news. I love
So
it.
people can
Excited
come
when
in
they
and they can get some, free advice, what would
Right.
work for them, what wouldn't.
Right.
So
Okay,
yes, that
that's
will
good,
be
that's good.
coming up.
Yes,
in the
that was a
future.
timely question.
Yes.
And I'll leave the other parts there for you guys to take care of that. But Christine and Juliet, thank you ladies so much for being on the show.
It's our
I was
pleasure.
so
Yes.
happy when you agreed to come, and I hope my listeners learn a lot from this show. We'll certainly have you two back on for some other topics. I want to thank you listeners for listening in. Please follow and like the show's social media on Facebook, YouTube, and Instagram. Also follow and like Quality Law and Corporate Services social media. Post your comments and or questions or even topics that you'd like to have aired on the show. And I thank you so much for listening. The show is put together to inform and educate the residents of the Cayman Islands and listeners everywhere of anything legal, including political, but not to be controversial. It's only to talk about anything legal. Thank you very much for tuning in again this evening, and see you next Monday on Legal Talk with Patricia Bryan here on Bobo 89.1 FM.